What happens after mediation? In other videos, we've talked about mediation. You can look to them if you'd like more details on mediation. But today we're going to talk about you've mediated, now what? I'm Jaclyn Robertson with JR Law Group, and welcome to Family Law Friday. Once the parties have come together in the format of mediation with a skilled third-party mediator, you and your attorney, the opposing party with their attorney, and have attempted to resolve any and all outstanding issues, there's different things that can happen from that point. So in the best case scenario, the parties will be able to come to an agreement. Usually that means there's been some give and take on both sides, and ultimately what's called a settlement agreement will be drafted up. And so that means for you, your work is pretty much done at that point on your case. If you've been able to reach an agreement, resolve all the issues, and get a settlement agreement, and in fact, this is an important piece, you will have the settlement agreement there before you that day, and it's very important that both you and the other party sign the document, as well as the attorneys. And then from there, the signed settlement agreement is something that will be filed with the court, and the mediation piece is done, and you're pretty much done. Now, at that point, if the parties have signed it, it's an enforceable contract. So it does mean something. But does it mean that your case is fully resolved and that you're divorced? No, not quite. Your work is done, but from there, the attorney will, one of the attorneys, usually there's an agreement as to who will do that, oftentimes it's the petitioner, will draft what's called the final documents. And the final documents are basically a proposed divorce decree. Now, the contents of the decree are completely taken from the settlement agreement. So once both attorneys approve the decree as consistent with the settlement agreement, and then there's a checklist of other cursory documents that need to be drafted and filed with the court as well. For example, just an affidavit of jurisdiction and grounds. If it's a case with children, there's some additional documents that need to be filed regarding the child support. So then once all of those documents are filed with the court, and then signed by the judge, once your decree is signed by the judge, you're divorced. Now, another scenario that you can see happen in mediation is the parties have tried really hard and some of the issues have been figured out, and there's still some issues that you just can't quite get on the same page. So from there, the parties can do a partial stipulation, and that means as to those particular issues upon which you agree, you draft a partial document, and that will be signed and that will be filed with the court. So that will resolve those issues that are addressed in that stipulation. Sometimes that's important if there's an agreement that the parties will list the house and sell it within 30 days, or the parties will equally split bank accounts, and while there still maybe have some unresolved issues with custody or other portions of the marital estate. So once that's filed, then you've kind of boiled down what remaining issues are outstanding in your divorce, what's still contested. So from there, you have a partial agreement, and then the other issues will move forward through the court process. Similarly, if unfortunately the parties come together and there's absolutely no resolution, then for a moment things can be a little bit at a standstill. But a lot of times, if you don't successfully mediate, a little time apart to diffuse the situation a bit, sometimes there's some missing information or evidence that will help get the parties on the same page. So sometimes parties will actually stop mediation, take a break, gather the information that's going to be helpful, take some time to reflect on the options, and then actually sometimes the parties will come back for a second shot at mediation. It's actually quite common, and then a lot of times effective, which means you've taken time, you have a second mediation, and then from there you can actually resolve all of your issues and do the settlement agreement and pursue the divorce on that initial positive, just resolved track. Similarly, sometimes parties come together a second time and they're just still not able to get there. So whether you have partially unresolved issues or if everything remains in dispute, then you've given your best shot at mediation, and you're now looking at you're still not divorced, and the next step is going to be pursuing your divorce through the court channels. And there's various issues that you will face and experiences and things that will come up with the court from that point. And that's what we're going to talk about next week. So you've mediated, you didn't reach a resolution, what happens next? I'm Jaclyn Robertson with JR Law Group. Follow me on Instagram at JR Law Group. Otherwise, if you'd like to speak more specifically about your case or schedule a consultation, go to my website at jrlawgroup.com. And otherwise, I'll see you next week.